Intellectual property. This is a new series for the first one. Here I will be discussing quite a few highly influential cases that actually defined the world of intellectual property as it stands now. First, let's take a look at the couple of cases I will be discussing. These are they. On here you can say Marvin, Gaye. Down here you can say Adidas, and of course the Barbie doll. You got Napster, and then yes, Java. Let's see why these cases are so important. Actually, these cases in fact define the current world of intellectual property. Going into the first one, the doll wars. It was between MGA and Mattel, another company. The case is interesting. You might see the content also. So, you know, the Barbie dolls came from, in a way, Mattel. But later, one of the employees of Mattel, right, joined MGA and developed a series of dolls. Out here you can see those dolls, right? You know, call them the Bratz dolls. The employees Carter Bryant, and later actually a Mattel company took legal action against MGA, telling that this doll, right, the Bratz doll made by MGA was technically made out of content copied from us, and this particular employee developed this skill when he was one of our employees, and when he joined your company he took that knowledge to you. It's a knowledge that belongs to us, so we should have the right, and this is a violation done by MGA. Initially, court agreed. MGA was made liable to pay $100 million of compensation. It's a huge amount of compensation for a manufacturer. But later, now that's the thing, right? This is why this case is very important. You know, MGA appealed to the Court of Appeal, the higher court, and there the decision was done in favor of MGA company, because the particular employee agreement was not very clear, not defined, not very clear. So should Carter Bryant be held liable for what he did for MGA? Well, the court decided he should not be held liable because the employee agreement is ambiguous. So Mattel does not get the right to the knowledge used by Bryant for MGA in making the particular doll. So, you know, this particular case made the entire industry focus on very, very carefully prepared employee agreements. What are these employee agreements? Agreements are the employee promises, or under contract, right, promises to you know, protect the intellectual property right of the previous owner or the current organization when he joins another company. So the ambiguity in the employee agreement prevented Mattel from taking legal action against Bryant successfully, and actually MG was, capable of, we got the right to claim back compensation from the Mattel company also. Nearly $1 billion. It's a long fought legal battle by both sides, which ended in favor of MGA just because, you know, the carelessness of Mattel in preparing a strong employee agreement. The weakness in the employee agreement resulted in, Mattel losing the case. So a very, very crucial case, and this is the case that defined most of the modern employee agreements. Now, most of the modern employee agreements are ironclad. That means there's no room for this kind of work. Employee who works for an organization is fully liable, right, to the company to hand over all the knowledge that he has. He can't just take the knowledge away and come up with a creation which is similar to the previous employers. This is Adidas versus Payless company. It's a case of strips. Take a look at Adidas is known for the 3 stripes, and here comes a Payless 4 stripes, looking somewhat similar, very close, and look at the dots and the black stripes. This is enough in this particular case, right, for the court to judge that the Payless company right, is liable for trademark infringement, that's that. Trade dress infringement, that's the outer work of the shoe, as well as a deceptive trade practices. That means this is done with the intention to deceive the public. In all three counts, the court found Adidas the winner, the Payless liable, and yes, the Payless company was ordered to pay $300 million of compensation, because Payless used this 4 stripes shoe and made 30 million pairs of sales. And this is considered as the biggest trademark infringement case ever. I mean, for the naked eye, you might see some dissimilarity. This is 3 stripes, this is 4 stripes, but the court found the content too similar, too deceptive. In trademark infringement, trade dress infringement, and deceptive trade practices. So, when one goes a look-alike of another, right? The court tends to be somewhat objective in determining the case in favor of the person filing the case. Next one is again a very, very crucial case that actually defines the future of the intellectual property with regard to the internet, the IT. The fight was between Google versus Oracle America. Oracle was a pioneer in the industry when it comes to the innovations and the inventions, and they came up with Java. So the case was the application programming interfaces. So, the issue was finally determined by the Supreme Court. We come back here by going forward a little bit. This is the history of Java. Actually, Sun Microsystems, the company that developed Java, right? Not Oracle. Later, Oracle brought it. That was in 1990s. 2003, yeah. Android came up by a company called Android. Later, Google buys Android. Then what happens? Yeah, later Oracle company buys Sun Microsoft. So that's the history. But the thing was that in creation of the Android systems, right? The Google uses around 11,000 or so, the API signatures of Java, right? So later it was, Sun Microsystems who created Java, but later it was acquired by Oracle. Oracle took legal action against Google, telling you're using a product, you're manufacturing a product which uses quite a bit of our stuff in your interface. For application programming interface, there are millions of codes in it, but more than 11,000 have been used by Google to create this thing. So, what's an interface? It's specification that, program to program communication from one program to the other. So it was a tough case. I mean, in this particular case, in a 6-2 verdict, that means 6 in favor, 2 against, decided that Google was doing fair use. So it's true that Google was utilizing Java parts of interfaces to develop its own things, but the court said it is fair use, it is no violation. Why? Because in the IT industry you do have to have this kind of some kind of a connectivity between the systems, and you cannot expect extremely rigid copyrights when it comes to using, reusing, and re-implementing things. And we cannot kill the innovation and the creativity. Just every bit, every code cannot be, every little bit of what's written, with regard to these interfaces cannot be given as a right to the company which decided. There should be a certain amount of freedom allowed for another application to copy some of it to create their own, because there should be inter-system connectivity. And that was decided by the Supreme Court of America, and this is what they said. Right, fair use can play an important role in determining the lawful scope of a computer program copyright. It can help to distinguish among technologies. It can distinguish between expressive and functional features of computer code where those features are mixed. Understand that. It can focus on the legitimate need to provide incentives to produce copyrighted material where examining the extent to which yet further protection creates unrelated or illegitimate harms in other markets or to the development of other products. Yes, you could allow fair use here. You cannot determine 100% protection for the creation of a script, because it should create some kind of room for other productions to come based on it, right? So initially these APIs, the application, the programming interface is free and open, allowing developers to build on others' work and innovate quicker without starting from scratch. Yes, program to program. So it was when Oracle fought a case over it, they were the first company to fight it. Had Oracle won the case, right? Had Oracle company won the case, it would definitely affect, whole of the IT industry, because you cannot prevent one program, one product to be inspired by another product, especially when it comes to the softwares. So, this particular case, right? Yeah, it's about 11,000 of it, of more than, I think, millions of other codes written by Oracle. Google has used 11,000. Yes, no permission was taken, and they created Android out of it, and the code said that we have to give this kind of a room in order to promote innovation. Stricter rules would destroy creativity, right? The fact that the programs depend on other programs is a fact that the court decided to agree. And yes, it's a victory for the programmers, developers and others. This is more heavily IT related, but this case contributed to the development of the internet in a massive way. And this is why the case is so important. It was decided in April 2021, not so long ago. So the JavaScript still belongs to Oracle, but this case allows others to use part of the script portion of it, right, to develop other programs. Not just JavaScript, other things as well. Now it's legal. Yeah. Earlier it was a long-held practice and the companies did not make a fuss about it, about these interfaces, but now, because of the Supreme Court ruling, no company can protect its own, what they've designed as an interface. Others should be given the right to copy that to develop their own. This case, right, it's an old case, heard in 2001, rather long time ago, 1999 to 2001, the case was fought. It's regard to free music. Napster came to the world giving the people the freedom to share files, peer-to-peer file sharing online. Now 2001 internet was nowhere near the modern internet, but when Napster created their own the platform where I, who buy songs, right, can share freely my songs with someone else without having to pay the original owner of the song, quite a number of people file legal actions, right? Many companies file legal action against Napster. This is their, the interface, right? It was such an easy system. Yeah, we could basically, I buy and I can easily share it to another. So that person can use it without paying anything to the parent company that made it. So, but then so many companies decided to take legal action. Right? Transfer of digital files through Napster service was not fair use, the court said. That is not fair use, because that will definitely affect the original creator of the song, because one person can buy it and can easily transfer it to other people without having to pay anything, those people, right? And the owner getting nothing. So peer-to-peer file sharing service of Napster, right, could be held liable for contributory infringement and vicarious infringement of a copyright. Yes. It creates a portal or a system where using that people could share files from person to person without having to pay. And the court said Napster was not doing it, but Napster created a platform where it's possible, right? And that is not, information technology could be developed by others. It's transformative development is possible, but you can't copy from one person to the other. That would be violation of copyrights. Transformative changes are possible. What's the meaning of that? I copy your content and develop something out of it, yes. The copyright law may allow it. Take a look at the interface case on JavaScript. But if you copy it as it is, free of charge, without having any payments to the original owner, that is, repeated and exploitative copying of copyrighted works, even if the copies are not offered for sale, could be considered a commercial, use that requires authorization from the copyright holders. Yes, I mean, imagine that you have a collection of songs in Napster. I copy the songs too, just to enjoy the songs myself, not to sell. Imagine that I hand it over, or rather my son or my daughter copies that and his friends take it. So none of them use it to make money. They all use it for private use. But the court said that kind of continuous copying and creating a platform to allow that continuous copying is definitely will be something that will damage commerce, right? That will result in people not buying, right? People using this particular system to obtain stuff free of charge, peer-to-peer file sharing. So in this particular case, the court decided just that's a violation. So this case determined the future of the internet. There are so much rules now. You can see that where the original content creators can protect them from being copied, unauthorized, right, from person to person. It resulted in the ending of free music per se, but not just the free music. So much of things in the world, right? This kind of continuous, endless copying without having to pay is stopped, because that will destroy the creativity of the original owner. This is again an extremely important case, and the case is still highly controversial. Many in the music industry is not happy about the decision, and the case was against Pharrell and Robin Thicke. They were Pharrell Williams, right? Very creative musicians of modern era, but the case was filed by one of the icons of the music, Marvin Gaye. Marvin Gaye was gone, and a long time ago, his family took legal action. His foundation took legal action against Pharrell Williams. The case was, Marvin Gaye's song "Got to Give It Up." You had to listen to the song, and the Marvin Gaye Foundation or family said that his "Got to Give It Up" has been copied or deceptively influenced, used by Pharrell Williams and Robin Thicke to create his song "Blurred Lines." And the court thinks so. Court agreed, and court said yes. The use of the same instrumentation and the feel of the original song is there in Blurred Lines. So the court found Pharrell Williams liable, and Marvin Gaye won the case. Marvin Gaye has been one of the most influential of musicians of the era, and he came from 1960s into 70s. He's one of those heroes of music industry, and his contribution to the music industry is unbelievable. He's one of the greatest of musicians. Pharrell Williams, on the other hand, one of those up and coming young musicians. So when you listen to the song, right? You listen to this song, then you can figure it out, right? I don't have to play it here. So "Got to Give It Up," and then yes, the Blurred Lines. So when the court went about the song, the court said yes, so structurally they are different, right? There are chord changes and all that, but the feel of the song, that's a new decision, right, is pretty much close to Marvin Gaye's song. So there the court said, Marvin Gaye has a right to win the case, and Pharrell Williams is liable. It's a pretty prolonged legal battle. So remember, take a look at it. The Blurred Lines has a difference in melody, in harmony and rhythm, everything, right? But the court said, right, the feel of the song is similar, the vibe of the song. So scientifically put, Technically put, Blurred Line is different to Got to Give It Up of Marvin Gaye. But the court said, the sense of the song, the feel of the song is closer. And Pharrell Williams was found liable. So in a 3-2 majority, 2-1 majority actually, right? The appeal court decided that Pharrell Williams is liable for, being deceptively, copying, Got to Give It Up by Marvin Gaye. So now there's a similar case against Ed Sheeran. Again, his Thinking Out Loud is considered has done some infringement on the Marvin Gaye's iconic song Let's Get It On. So listen to these songs to find out, right? Let's Get It On goes for a longer duration, so he's got to give it up, right? They were iconic, the world-class classics of Marvin Gaye. And are these modern artists like Pharrell Williams and Ed Sheeran, are they liable, for the feel of the song be same? So, of course, there was one judge who did not like the decision. He said, the music style, he said, should not be protected. It should be given people should be given the chance to use it. So the bass lines, the chords, and the groove should not be protected of the song. But in this particular instance, the court was of a different opinion, right? So this also has made huge changes into the modern industry. So yes, the fair use is true aspect. We have to create the original creators, but how far is too far? When we copy something, yes, it's transformation to developing it somewhat, right? But can we transform with the slighter changes or make bigger changes? How far is that to get transformation to be okay from copying? Copying is illegal, but transformation was all right. But these cases kind of all the cases that we heard, right? The Marvin Gaye case here, and then before that the Napster one, of course, technically copying content to others. But take a look at the Java case, the Google versus Java, developing the current thing into something else, right? And then even Adidas, right? It's a case of something simple as stripes. Should Adidas be given the right of this black stripe? Court said just. And then the Barbies different to the Bratz dolls of MGA, but the court was not convinced. So these cases actually in a way define the modern intellectual property law. So exact copying is illegal, transformation is allowed, but when it comes to transformation, all kind of transformation is not allowed. There are scenarios where the court will come up and draw the line, telling this is alright, acceptable, or this is definitely not acceptable. So these few cases, especially something like this, right, the Marvin Gaye versus Robin Thicke and Pharrell Williams, right, they define separate industries. So manufacturing to IT, right, to music, right, what is the limit? Where stands the level of acceptability? And if you cross it, is it a violation? Yes. So these cases actually defined not just the industries, it has to define laws as well. Take a look at the case that's coming up with regard to Ed Sheeran's case, right, where he's facing a case by Marvin Gaye. So this issue is getting updated continuously. Catch you in another lesson.